speak at that stage. But I know Sir Jeremy Wright has an amendment. So I call
Thank you very much, Dame Rosie. And as you say, I do, in fact, two, and I want to focus my remarks on them. They're amendments 54 and 55. Dame Rosie, of course, we all understand the purpose of this bill is to allow this Parliament to designate Rwanda as a safe country so that people can be returned lawfully to it. But of course, to achieve that, you require a definition of what a safe country is. And the bill does that in clause 1, subclause 5, and particularly 1.5a, which describes a safe country as a country to which persons may be removed from the UK. So far, so good, Dame Rosie. It seems to me that's an essential part of the bill's inherent purpose. But the part of the subclause that concerns me and on which my amendment is focused is what it then goes on to say. So that in fact what 1.5a says is that a safe country is a country to which persons may be removed from the UK, and this is the bit that worries me, in compliance with all of the United Kingdom's obligations under international law that are relevant to the treatment in that country of persons who are removed there. In other words, it seems to me the bill is saying that the United Kingdom can, by means of this legislation, by saying that Rwanda is a safe country, also deem itself to be in compliance with a set of its international law responsibilities. And I don't, Dame Rosie, think that can be correct. Now, there are few in this House, I suspect, as familiar as I am with the vagaries and complexities of international law. But surely if international law means anything, it must mean that it does not lie in the hands of any individual nation state, even this one, to determine its own compliance with international law. And if it were otherwise, international law wouldn't really be international, and it certainly would serve no purpose in containing bad behaviour, as we sometimes ask it to do. I give way.
I'm very well aware, I work very closely with my honourable friend in a number of ways, as he knows. I'm very well aware that my honourable friend is a former Attorney General. And if he were right that it's not for the government or this House to determine whether measures are compliant, why on earth would they seek and get the Attorney General's advice on just that?
My right honourable friend knows that the Attorney General is consulted on a variety of different legal questions, both domestic and international. He wouldn't expect me to disclose any of the advice I have previously given, but I can tell him that the Attorney General does give advice on whether the government's actions may or may not be in compliance with international law. But the Attorney General, and I don't think the government, expects to be the ultimate arbiter of that question. The advice is given as to whether or not it is likely that this action would be in compliance with the law. And I'll come in a moment to what I think the bill and the government can properly do in relation to international law responsibilities, but it does seem to me that what it can't properly do is to set itself up as judge in its own cause on questions of international law. And this House would be wrong to pass a bill that suggested that it could. And that's really where my amendments are focused. And as I say, there's a good practical reason why we should be nervous about this, because we do sometimes rely on international law in order to discharge our own policy intents and purposes. And not more than 48 hours ago, in this place, we were doing exactly that. We were saying that it's important to criticise the actions of the Houthis in the Red Sea because they contravene principles of international law. And we were saying, too, that we justify our own response to that because it is in accordance with the principles of international law. And quite right, too. We would not have accepted the Houthis' unilateral declaration that they were in compliance with international law when they did what they did, nor should we have. And we wouldn't, of course, accept a Russian legislative act to say that the invasion of Ukraine by Russia was in compliance with Russia's international law responsibilities. Now, I make it clear, Dame Rosie, I'm not, of course, suggesting the government has in mind here is in any way comparable to those two examples. But it does seem to me that the point here is that to arrogate to yourself the right to declare your own compliance with international law runs the risk, first of all, of other states finding comfort in our example, and secondly, of undermining our own messages in other situations. And that, if I will in just a moment, and that in my view makes this not just bad law, but also bad foreign policy. I give way.
Thank the young gentleman for giving way, and I'm very pleased to hear what he has to say on the question of international law. Does he therefore share with me, and I am not as legally qualified as him, I would fully accept that, a concern that the government's own legal advice states that by stating that the bill is incompatible, it makes it compatible. Is that not worthy of the Mad March hare when it comes to consistency and standing up for the rule of law?
I suspect what the Honourable Lady is referring to is the statement of incompatibility at the beginning of the bill with the Convention on Human Rights and with the Human Rights Act. And of course, that provision is there for a reason. It's to allow the government, if it so chooses, to act in defiance of those responsibilities. That is perfectly proper, and I'm going to come on to explain why I think that is something the government can properly do. What I'm concerned about is something a little different, which is instead of saying, we don't think this is in compliance with international law, we're going to do it anyway, instead of that, saying, we think this is in compliance with international law, it's down to us to decide that, and we have so decided. That feels to me as though that is something that we could not and should not do. Now, Dame Rosie, it would be concerning enough, in my judgment, if this bill only tried to deem the UK's compliance with international law, but it also seems to say that we can deem Rwanda's compliance with international law. And that is set out, of course, in clause 15b, which goes on to say that for the purposes of this Act, a safe country includes, in particular, a country from which a person removed to that country will not be removed or sent to another country. Again, so far so good. That's essential, it seems to me, to do what the bill seeks to achieve. But it goes on to say, in contravention of any international law. And again, it cannot, it seems to me, lie in the hands of this Parliament to decide whether or not a country may be removed to another country in contravention of any international law. And it goes on in B2 to say that, again, a country would be a safe country in which any person who's seeking asylum or who's had an asylum determination will both have their claim determined and be treated in accordance with that country's obligations under international law. So what it seems to me the bill is seeking to do is to say, if we deem it so, not just is the UK in compliance with its international law responsibilities, but Rwanda is going to be as well. And that feels to me not valid and somewhat over-ambitious. I happily give way.
Whether my right honourable friend, who has great experience as former Attorney General, would agree with me that actually the deeming provisions under the Withdrawal Act creates another rather similar situation, because we deemed EU law to be UK law, and therefore, on the analogies he's just given, that he would argue, I imagine, though I think he might even have been Attorney General at that time, actually did exactly the same sort of thing, although I am listening with great interest to the very more precise point he's making about this relationship with international obligations, on which I will speak later.
Very grateful to my right honourable friend for his intervention. And I know, Dame Rosie, you would not want me to abuse the privilege that you've given us to range slightly more widely, to range quite that widely, so I won't. But he's right that I'm making a fairly precise point about what this language appears to me to say. And I stress, I don't think, in order to achieve the objectives the government has set in this legislation, with which I have some sympathy, though their methods make me nervous, and I make no bones about that, I do not think it is necessary to include this language. And I think, worse than unnecessary, it presents some dangers, which I don't think we need to present in order to achieve, as I say, the government's objectives. But look, I completely understand, and I suspect my right honourable and learned friend, the Minister, will tell me in a few moments or hours' time that I don't need to worry about any of this, and he may say that that is for two reasons. The first of those is he may say, well, the bill doesn't mean what I think it means. Well, you'll forgive me for saying this, Dame Rosie, but I'm getting increasingly troubled in this place that we answer points such as mine by saying, yeah, but it doesn't really mean that, and we don't really mean that by it. I think we have to be concerned as legislators with what the language we are passing into law actually says, not what we meant it to say. And I am concerned that what this language says is not, I'm sure, in accordance with what my right honourable friend wants to do or the government wants to do, but it might nonetheless have that effect or be taken by others to mean the things that I am concerned about. And so when it says what it thinks a safe country is, this bill, it seems to me it's potentially confusing two different things. One of them is deeming your own compliance with international law, which I don't think any country should be able to do. And the other is saying that Parliament resolves to do something even if it contravenes the UK's international law obligations, which, going back to the previous intervention, I do think the British Parliament can do, and we as a legislature can resolve to do, we so choose. We have to decide, of course, whether that is a wise and sensible thing to do, with all the ramifications it might bring, but as a matter of law, it seems to me that the UK Parliament can, if it wishes, pass a law to say, despite or irrespective of our international law responsibilities, this is nonetheless what we want to do. But that is not the same as deeming your own compliance with international law, which I worry this language almost certainly seems to do. And the point I make about the UK Parliament being able to do things, even when they contravene its international law responsibilities, is of course already in the bill, already reflected in the language of clause 1(4)b, which points out, and I quote, that the validity of an act is unaffected by international law. Well, quite right. So we can, if we so choose, deem a country as a safe country for the purposes of domestic decision-making, if we want to. But what I don't think we can or should do is to legislate to say we comply with our international law responsibilities when we do, and crucially, as I say, to achieve the objective of this bill, we do not need to. So the second reason, Dame Rosie, why the Minister may say I do not need to worry myself about all of this is because he may say that domestic and international law exist on different planes, and this legislation is only targeted in any event at domestic authorities, so the bill couldn't, even if it chose to try, deem our compliance with international law in actual fact anyway. And I would agree with that. It is perfectly true that domestic law and international law operate on different planes, and it isn't likely, this bill, to determine any question of international law before any international tribunal. But if that is so, why include the language? If it doesn't have any meaningful legal effect, it doesn't serve any purpose, but what it may do, I fear, is send a damaging political signal to other states. So, Dame Rosie, it seems to me that the language I am concerned about, and which Amendments 54 and 55 would remove, is either offensive or it's otiose. And in either respect, the bill will be better without it.